Hi, I'm Michael Cohen. I'm a Dallas estate and elder law attorney. I'm joined by Don Crawford Jr., if I could say it correctly.
Oh,
You know how it is after the beginning of the year, you can't say anything right.
right,
It's
exactly.
all that drinking that I never do. So
Right.
I don't, I have never drink. So it's kind of, I have no good excuse for that.
That's good.
So Don is generously offered to be a co-host on this show, just like we did on the radio. And so he usually asks questions. I have no idea what questions he'll ask. Today's topic is on frequently asked questions regarding powers of attorney.
In Texas.
In Texas, yeah, each state may have different laws. We have a statute. It's in our state's code about powers of attorney. In fact, there's even a form, statutory durable power of attorney.
Wow.
But usually we add a lot of extra stuff, a lot of extra things that the power of attorney doesn't include. Why is it? So there's a statute, a law, and it's actually about 10 pages long that says all the different things that's covered. So, for example, real estate transactions, sell, convey, lease, hypothecate, mortgage, assign, transfer, deed of trust, life estates, whatever. It tells you all that in the actual law, but it doesn't have it on the document. It just refers to the statute, the law. Durable, and so usually when we're talking about a statutory power of attorney, it's a financial power of attorney dealing with your assets.
Okay.
Now, durable means it's good even during your disability. So that's when you want it to be good, is when you're disabled. Uh, Now, it usually terminates on death. Usually 99%, if 99.5% of the time. So when would it not terminate on death? Well, there is surprisingly an irrevocable power of attorney, but only to be used for LLCs, limited liability companies, for people to wrap up things after death. That's in the business code.
Okay.
Uh, People can have it effective immediately. You can either have it effective immediately, a power of attorney, or it could be springing upon your disability. A lot of people think, oh, yeah, I just don't want it to be happen when I become disabled. But really, it's best generally to have it effective immediately because it's often difficult to determine when somebody no longer has capacity. And
And
you
who
don't
determines
go to
that? A doctor or who
yeah,
did
yeah,
that?
yeah.
Oh,
You'd have to go to a doctor. And, usually when we have questionable capacity situations, we actually have an affidavit for the doctor to sign, preferably somebody who specializes in the mind, a neurologist, geriatric psychiatrist, that type
huh.
of doctor. So in the affidavit that we usually have them sign, they say, okay, I've examined Joe. And when I examined him, he had enough mental capacity to know what he was doing to sign a will, a trust, a power of attorney, whatever it may be. And a power of attorney could be very broad. When it could be usually when you think about a financial power of attorney, it's very broad. It could do all sorts of different things. But even the statute doesn't cover everything. Or it could be limited. It could be limited. So the broad statutory power of attorney or adding extra things could cover everything from real estate, like we said, to signing a contract, to borrowing, to dealing with a limited liability company. It could be any number of things. And then on top of the statutory language, you could add other things like amending your trust or creating a new trust or doing gifting or creating rights of survivorship accounts or changing beneficiary designations or substituting one agent to act for another agent, especially if there's somebody can't act. So there's all sorts of extra things that you could add in addition to the statutory language, and in addition to the extra language that called the hot powers, you could add even more stuff.
Okay.
So, okay, I give the permission to seek a divorce or marital partition or the real estate occupations code. It goes on as you could imagine, and you can make it whatever you want. So it's not one, don't think of it as one standard form. I never use a standard form. I
Okay.
use extra things, just the way it is. So it's best to probably be immediate so you don't have to go to the doctor and wait and delay. or some people just want it springing, but it's generally best to have it immediate
Okay.
and durable. Of course, you have to have it durable so it's good even during disability. When is it, who could sign it? Well, you have to be over age 18 and have enough mental capacity.
Hmm. Okay.
When does it become, when does it end? Well, typically at death. However, you could always revoke the power of attorney.
Oh,
Or if you got divorced, it's terminated as a matter of law.
interesting.
Yeah. Now, if when you have real estate, if you own real estate that's not in a trust, then you should we recommend that you record the financial power of attorney in the county where the property is located because only an original power of attorney could be recorded. A photocopy won't work. So let's say if you lost your power of attorney or it got destroyed by a fire and you wanted to sell your home, but you lost mental capacity. Well, if you had recorded, it wouldn't matter because now it's a matter of public record.
Okay.
Um, and so if I did record a power of attorney and I wanted to revoke it, well, you should file the revocation as well. And probably we have one this week where we say, okay, we're revoking the power of attorney and we're also giving notice to whoever was the agent that their power has been revoked. When you do a power of attorney, that's the one who signs it is called the principal. The one who has the power to act in addition to yourself is the agent.
Aging. Okay.
So there's sometimes you'll see it says, it used to be called your attorney in fact, but so now they call power of attorney, but now it's actually the person who acts for you is your agent. Uh,
Okay.
it's really something what happens if you don't have a power of attorney? What happens if you don't have a power of attorney? Well, and you have real estate and you lost mental capacity. Well, then you have to seek guardianship to sell the property. Well, that could be very expensive because there'll be a couple attorneys, one representing you and one representing who seeks to be in charge of you to relieve you of your rights. You'll have to have doctor's letters. You may have to get the court to approve you selling the property. You might have to have an annual accounting. So I guess what I'm saying is a power of attorney is a cheap disability planning document that everybody probably should have. Even if you
Right.
don't have any assets, you might let's say you need to go into a facility and somebody needs to sign a contract for you. Well, power of attorney could do that.
Beautiful.
So I think it should be recommended. Let's say you have a retirement account, even if you had a trust. How is how are you going to get to the retirement account? Let's say there's somebody who was married. Just because you're married doesn't mean you have authority over your spouse's IRA or 401k. So you really I have two daughters, and when they turned 18, I did all the basic documents, including a power of attorney, even though they had limited cash assets. So that's my recommendation. Those are some of the frequently asked questions that come to my mind. There's probably more. Probably if you gave me more time, I'd probably come up with more questions. But those are the ones that come to my mind now. Don, do you have any particular questions?
I don't have any questions. I just think that you've been advocating powers of attorney for years. You've been such a big fan because they're so important and almost an integral part of everybody's plan. Do you still feel that way today?
Yeah, I do. And also, I should have mentioned that that's different than a medical power of attorney. A medical power of attorney is only dealing with medical decisions. A medical power of attorney only springs upon disability, unlike a financial power of attorney, which you could have it effective immediately or spring upon disability. And the
Okay.
laws are different from state to state, by the way, on that.
Okay. Good. No, that makes it very clear. You've been a big fan and you still are today, and I agree completely. And I know I have one, so we're in good shape there.
Yeah. So yeah, and everybody should have a medical power of attorney as well, as long as you trust somebody. So I guess that gets to be the big question is how much do I trust an individual?
Right.
And then if you don't trust them, then you probably shouldn't have them as an agent.
And I have seen, Michael, so many times just recently too, how money does things to people. And maybe this person, what do you call it, the agent, seems trustworthy, not greedy. and then they start to see dollar signs if this person is getting older or passing, and then they just change on them. So that means it's a, do you call it a revocable power of attorney?
Well, no, you
Okay.
can always revoke it. The
Okay.
problem is you have some people who, when the person lacks capacity and they have them sign a power of attorney and they abuse it. When somebody abuses and takes some stuff for themselves, let's say that there was no gifting authority and they take money for themselves, it's a crime.
Yeah.
And it goes, the level of the crime increases with what has been taken.
Wow.
So you better trust the individual. Now, I had somebody this last week. I said, well, it's recommended that you be effective immediately. And he said, well, I want it to only spring upon disability. I said, do you not trust that agent? If you don't trust the agent, they shouldn't be it to begin with. She said, I don't trust anybody, but I want power of attorney.
Right. Funny.
Okay,
Yeah.
whatever you like. It's whatever.
And maybe it's good advice. Maybe no one should trust anyone. One of the first things my father told me 40, 50 years ago is trust no one. And just because it's hard to do that, I don't agree. You have to trust people because life is too short. And I believe in people. I trust you completely. I trust a lot of people. But I guess he just meant professionally because you're going to get burned.
Yeah, and there are some very powerful power of attorneys which could give um, where easily somebody could get burned. And that's why they're commonly known, those extra powers, as hot powers.
Hmm,
So
interesting.
if you're interested in knowing more about any estate planning documents, feel free to go to one of our estate planning essentials workshops. We have them every month. To do that, all you have to do is call 214-720-0102 or sign up online at dallaselderlawyer.com. That's dallaselderlawyer.com. Only for the people who go to the free 2-hour estate planning essentials workshop get a 1 hour free vision meeting with me to go over without obligation, to go over whatever your issues may be. So 3 free hours of legal education without obligation.
And that last hour is private, it's
Yeah.
individual, which really is helpful for people because a lot of times people don't want to uh, air their dirty laundry or talk about their personal issues publicly. So I like that a lot.
Yeah, no, it's private. So at the workshop, we ask people what they want to know, and then we kind of write it on a board and then see what they want to know and answer the questions and have some basics that we also tell people. But every workshop is different. Everybody learns from each other because they never thought about the questions of the other person, and then they say,
Right.
"Oh, gee, that applies. I never really thought about that."
Exactly.
Anyway. All right. Well, thank you, Don. Again, happy holidays to you. And